Good afternoon, everyone. I welcome you all to the webinar of ICSI IIT, that is Final Word on IBC. We have with us two faculties, Mr. Snehal Kamdar and Mr. Anil Goel. Today, we shall discuss three Supreme Court cases, Punjab National Bank versus Mr. Vijay Sitaram Dannayak and another civil appeal number 2277 of 2021. TechSharp Engineers Private Limited versus Sanghvi Motors Limited, civil appeal number 296 of 2020. Asset Reconstruction Company India Limited versus Tulip Star Hotels Limited and another, civil appeal number 8485 of 2020. The first session shall be taken by Mr. Snehal Kamdar. I'll provide you the brief profile of Mr. Snehal Kamdar. Mr. Snehal Kamdar is a senior partner in Messrs. Jain Jagawat Kamdar and Company Chartered Accountants, having its office at Mumbai. He is a director in JJK Management and Financial Consultants Private Limited and Kunbi Sehkari Bank Limited. He is advisor to the board of Martrise Consultants Private Limited. He is managing trustee of IP Foundation, a charitable trust formed for creating awareness in the society on insolvency and bankruptcy for 2016. He is actively involved in events of ICAI, have been speaker on the topics such as project financing, debt syndication, debt restructuring, credit rating, insolvency and bankruptcy code, etc. He is a part of Insolvency WIRC committee. He was a special invitee member of ICAI Central Council subgroup on insolvency. He is a regular speaker in various training programs, webinars, etc. So you may now start the session.
Thank you. Thank you for giving me an opportunity to share my thoughts on this and for a brief introduction. Today, me and my colleague all
So you're not audible.
Can anyone help me whether I'm audible to you either by chat or unmuting?
So now you're audible.
Yeah. Sorry, it got disconnected for a second. I think network issues came. No issue. So now you are. Thank you. So today, basically the ups and downs in IBC that we see and how this Limitation Act has a role and how the things are basically to more or less the discussions by explaining the Supreme Court judgments will be on how this Limitations Act has played a role in the IBC. So in the matter that I am dealing in the first part, Punjab National Bank appellant and Vijay Sitaram and Dannayak and others as a respondents. Here NCLT admitted the petition under Section 7. It was appealed at NCLAT, where at NCLAT it was dismissed, stating that yes, the Limitation Act applies in this case. Went to Supreme Court and Supreme Court again admitted. Now the event of things that took place during this process and how it was first admitted by NCLT on what grounds NCLAT took for dismissing, and then what grounds Supreme Court clarified in this judgment is the matter of discussion. Friends, many of you, I can see, I know many of the participants in this batch. So many of you have heard me also. I like to have some interactions during the session. I have 1 hour session. By 5 o'clock, I have to wind up. This session, basically, when we discuss this matter, when we go through the case law, what we will try to highlight is how the questions arise of law, which was questioned, and then how it was being dealt. Because this will give us a very good insight on how the process runs. As a RP, many of us, the one who are attending, most of us are practicing IPs. Okay. I also see a practicing advocates in the participant thing. So here, basically, we will try to see that how the Limitation Act played a role in this matter. So to start with, the order starts with the order of admission of this petition under Section 7 was passed by NCLT, which has been reversed by NCLAT on the ground that the application was bad by limitation. The financial creditor PNB basically has come up with the above appeal. So the matter which was admitted was again put to a halt by NCLAT, and now it has been dealt in Supreme Court. So here in the Supreme Court, a brief about the matter was that the appellant had filed a Section 7 application against Messrs. Jai Lakshmi Sugar Products Limited, the corporate debtor, who is the second respondent herein claiming inter alia that the sanction letters. So PNB has given the funds to Jai Lakshmi via sanction letters 2010. Here, when we are looking into Limitation Act, the dates play a very crucial role. When the debt gets time barred, when the claim, whether there are two parts when we talk on this. One part is a right to claim till when it continues, and another is the dispute now in the matter when it is filed at a tribunal, whether the matter to be admitted. So if there can be a debt which is time barred to proceed in the litigation, but that debt does not take away the right of claim. So when the claims are filed and the claims are more than 3 years, what we talk from 3 years from each state, whatever is the discussion that we take today. So that 3 years for claim is not relevant. Filing of claim. What is relevant is for filing of application, the Limitation Act is applicable, is important. Am I clear on this first point? Yes. Can some participant be interactive? Because in virtual session, it becomes really challenging for a speaker to understand whether he is able to push his thought.
अंदर जी एक बार फिर बताइए ना इसके बारे में.
Yes. So the first point that I wanted to put it across to you was claims and filing of application. Limitation Act comes into play for filing of application. For claims, it does not come into play. Okay. Now moving further on the thing, in this matter, the sanction letters were dated 2010 May and September 2010. A term loan was sanctioned. Thereafter, the letter was issued for restructuring on September 2011. Restructuring the term loan. So in September, 28th September 2010, and a fresh sanction of term loan was granted to the corporate debtor. The corporate debtor defaulted in repayment and became NPA as on 31/3/2030. Okay, so now NPA date is 31/3/2030. The appellant issued a demand notice, that is PNB issued a demand notice on 34, that is 30th April 2013. So after NPA, within 30 days, demand notice under section 13(2). of SURFACE Act was issued. The corporate debtor also executed the balance and security confirmation letter. Okay, so there was a confirmation letters issued on 3rd July 2014, and then after 3 years from that, that is 17th June 2017. Okay, this dates just keep in mind on the discussion that security balance confirmation are issued in 2017. So 2013, your account was NPA. Okay, you initiated under SURFACE within 1 month of becoming NPA, and you have taken the confirmation on 14 and 17. Okay, the 2017. Now moving on that application, the appellate along with Union Bank also filed a OA in DRT Pune for issue of certificate of recovery. The original application was allowed in DRT Pune by order dated 1st November 2016, directing the corporate debtor and others, including respondent 1, herein jointly and severally to pay the appellant the sum around 45 crores together with interest at the rate of 16.25%. The total amount outstanding as on 13th August 2003 was 108 crores. So 108 crores, 34 lakhs 33,000 is the amount that was as on 13th August 2019. And that in parallel proceedings at High Court, the Bombay High Court had passed an order in 4th January 2018 directing the winding up. So what happened? Account became NPA. Okay, account became NPA in 2013. SURFACE initiated in the same year, 2013. 2014 confirmations were taken. 2017 confirmations were taken. Parallelly, the matter was filed in DRT, so that OA which was filed in DRT in 2014. So one side SURFACE is on, another side DRT is on, and simultaneously in the High Court, the winding up petition was filed. So for the recovery of same dates, 3 places, the at different date, the different proceedings continued under different acts. Okay, going further, by an order dated 2019, NCLT admitted the application under section 7. So 1 proceedings under SURFACE, 1 under DRT, that is under the RBD Act, 3rd under Companies Act for winding up, and 4th under the IBC code. 4 proceedings. Limitation, the first sign. As a shareholder, promoter, and director, appeal to NCLAT. Dated, so it was appealed, the order dated 21. Impunged this appeal, the NCLAT set aside the NCLT order. So on the ground that the claim of the appellant is financial credit, in this case PNP, were barred by limitation. So initially when the application was heard, it was not barred by limitation. Then it came that it is barred by limitation, and it was basically barred by limitation. So the order is set aside by NCLAT. Now just remember that there is something known as section 238 also, which will come in play here, because we are talking on this into play. So before going on the Limitation Act, let me just take you 1 step ahead on this order. So before NCLAT, the respondent first raised the preliminary objection that in the light of the order of a winding up passed by the High Court, the application 7, so it was not maintainable. So what was that point that they had raised was the preliminary. They did not dispute anything. They want on the technical ground that if the winding up application is already there, then this matter should not be admitted under IBC under section 7 was the ground that they had. So NCLAT rejected that ground. That okay, maintainability under section 7 is not a challenge. What of Jaipur Employees Organization versus Jaipur Metal and Electric Limited other. In this matter, this point application can be maintained under with any.
Interrupt, but your voice is breaking. It's not clearly audible.
Okay, what? Yeah. Okay. Am I audible now?
Yes, sir.
Okay. So now in this matter, that the maintainability of application at NCLT, when winding up application at High Court is there, is maintainable. Now the NCLT took up another consideration, the question of limitation that was raised by them. So after overruling first part, where it was maintained that it is maintainable, application 7 is maintainable. Now the question of limitation came into discussion. So, yes, sir, anything you want to say, sir? Kumar, sir?
No, nothing. Just that your voice keeps breaking. I don't know if you need to rejoin again, sign out and sign in again. I mean, it keeps happening.
Okay, okay. Just give me a second. If you allow me to just rejoin, I think I will just try to check. Give me 2 minutes to exit and rejoin. Okay.
Okay, thank you.
Yes, friends. Hope now I am clearly audible.
Yes, thank you.
Okay, okay. I will do one more thing. I will try. I will keep my video off. I don't think we require video. That will help me to have a bandwidth issue sorted out. Okay. Yes, friends. So we were on the point where the NCLAT basically took up the second point that was raised. That was the limitation, question of limitation. So in this matter, the NCLAT opined the decision of Babulal Vardharji Gujjar versus Veer Gujjar Aluminium Industries Private Limited and clinched the issue on the question of limitation. What was that? That the application under Section 7 filed in 2019 was beyond 3 years from the date of default NPA, that is date of NPA, namely 2013. Okay, now 2013 was the date of default that we discussed. What they are saying, the application which is filed in 19 is beyond 3 years, so it is time barred. Okay. Further, they said that the balance and confirmation letter which were issued in 14, so from 14 also 2019 time barred. There is a confirmation letter issued in 2017. Okay. Now, when you see from 2017, so there was a confirmation letter given by the corporate data to PNB on 17/6/2017. From that day, it is filed, and as such, normal understanding that from confirmation, once it is there, from that day, 3 years to be considered again. But in this case, they came out with the point that 2017 confirmation was received after 3 years. So last confirmation they had was 2014. So what was the date of 2014 that we had discussed? So it was 3rd July 2014 that the confirmation was issued. So 3rd July 2014 to 2nd July 2017 should have been the confirmation date, if it has to be in time within 3 years. Here it was, instead of 3rd June, instead of 3rd July, it was now 17th date. So the NCLT came that NCLAT came saying that it has been issued after the expiry of 3 years from the date of default. So 2017 confirmation is after 3 years. So 2013 date, from 2013 to this date was considered. They missed on the 14th confirmation. So they say that after the expiry of 3 years, the date of default, and as a consequence, Section 18 applies of the Limitation Act, and that's why the present appeal basically needs to be dismissed. So in that case, the Section 7 application should be dismissed. Am I clear on this point? Yes.
Yes.
Okay. Thank you. But on perusal of the records and careful consideration of these things, what NCLAT failed. Now that is what the Supreme Court took over. So Supreme Court started saying that as per Section 7(1) of IBC, enables financial creditor to initiate corporate insolvency resolution process when default has accrued. Okay. So when the initiation takes place of a CRP, when the default has accrued, the explanation under subsection 1 of Section 7 makes it clear that a default includes a default in respect of a financial debt owed not only to the financial creditor, but to any other financial creditor of the corporate debtor. So here, the Supreme Court went on to say that, first of all, Section 7 application. So who can make the application, when it can be initiated, and default clearance of that Section 7 subsection 1 clearly says that a default includes a default not only with the case of financial debt owed, but also to the applicant financial creditor and any other financial. So there should be a default that needs to be proved. The fact that the corporate daughter has been ordered by the High Court of Mumbai to be wound up is a proof to show that the case falls under the category of Section 7(1). So maintainability of application under Section 7(1) again has been affirmed by the Supreme Court. In NCLAT, it was also affirmed based on the IBC that in light preliminary objection when at it was raised, they said that section 7 was maintainable. Here they clarified why it was maintainable. They went further to now go to the definitions of the word default that is being defined under section 312 of IBC. So what does the default definition says? It says that the default means non-payment of debt when whole or any part or installment of amount of debt has become due or payable and is not paid by the corporate debtor as the case may. So it says that default under section 312 of IBC comes into play when there is a non-payment of debt, whether in whole or part or installment, when it becomes due and payable and not paid. So it is due and payable, not paid. They further went on to clarify about section 238A that was inserted in IBC. So this 238A, you will also, my fellow friend, when he takes the other case law, 238 elaboration is there in that case law of Supreme Court case. So he will take you to 238 in detail on that. But here, what we in this matter, it said that 238 was inserted, provide that the provision of Limitation Act shall, as far as may be, apply to the proceedings or appeals before the adjudicating authority or unclaimed. By virtue of the above amendment, the doubt, if any, in the question of applicability of law of limitation to the proceedings under IBC got clear. So the key point on this 238, the various sections under IBC Act came into force at different dates. So that other case law, which Anil Bhai will be taking, in that they have clearly given this bifurcation that in what date 238 came into play and what was this issue. So the day when the initial in December 2016, when the certain section came into play, and the date when this 2018, this section 238 into case. So between that period, how the things happened. But the amendment by way of 238 made it clear that when it is to be thought of maintainability under section 7 under IBC, then you have to understand that the Limitation Act applies. Now, what is Limitation Act is what we will be speaking further in this case law. And in the next, the speaker will also be taking you to that details of the what is the Limitation Act says. Okay. So it may be noted that the different provision came into force. Like as I said, section 4 to 32 and section 60 to 77, section 198 to 31 and 236 to 38 came into force on 1st December 2016. Okay, wide SO number 3594 dated 30th November 2016, and 238 was inserted and came into force from 6th June 2018. So there was a gap between the two the sections that were initially came into force, and then 238 was later admitted. After its admission, the matter is clear, Limitation Act applies. Before that, a lot of litigation took place. So therefore, a question that arose in BK Educational as to whether Limitation Act apply to the application under section 7 or 9 of IBC from its commencement till the date this section comes has been taken a note in that case. So BK Educational Service gives you idea that yes, Limitation Act applies, and that was the case law. And then amendment came, and for thereafter now there is the act is amended to have an additional section which clearly says that it applies in the application that is to be filed. Okay, so this the Supreme Court took the note of section 337 of IBC, which make reference to Companies Act 2013 insofar as words and expression not defined in IBC are concerned. and made a reference to section 408 and 424 of Companies Act and came to a conclusion that by virtue of section 433 of Companies Act, the provision of Limitation Act will apply even to proceedings initiated before insertion of section 238A. So as I told you, the date initially that 1st December 2016 sections came into force. From that date till 238, the question was that whether the Limitation Act applies. So here they reiterated that after 238 there is no doubt that Limitation Act applies, but during that interim period also they made it clear that it applies to the proceedings that are initiated under section 7 or 9. So as a consequence, the Supreme Court said that the Article 137 of the Schedule of Limitation Act, which prescribed 3 years from the date. Now, which date? So this is Article 137 of Schedule of Limitation Act says that it is the 3 years from the date when the right to apply accrues. So when that right accrues to you to apply to a suitable forum, the Limitation Act comes into play and it gets over from that date till within 3 years. So to an application for which no period of limitation is provided elsewhere, this will be applicable. So they concluded that on this, that right to apply wherever accrues. So from that date, 3 years. So in this case, what is the date that comes? That will be discussed, that right to apply accrues. So from that day, 3 years. So when the application is filed in 2019 with NCLT, whether it comes within that 3 years from the date when the right to accrue comes or not. Okay, apply accrues or not. Going further, it goes down to a ratio of BK Educational Service and found an elaboration in Jignesh Shah and another cases versus Union of India, where Supreme Court has held that a petition for winding up to be barred by limitation as it is filed beyond 3 years from the date on which cause of action as mentioned in an already instituted suit for a specific performance or damage arises. The two important principles that came out from the decision of Jignesh Shah were: point number 1, a suit for recovery based upon a cause of action that is within limitation. So a cause of action needs to be defined when a recovery suit is filed. Okay, so a suit of recovery based upon a cause of action that is within limitation cannot in any manner impact separate and independent remedy of winding up proceedings, and hence the proceedings for winding up should have been initiated before the expiry of the period of limitation. And second principle they came was, when the time begins to run, it can be only extended in a manner provided in the Limitation Act. Say, for instance, the acknowledgement of liability under Section 18 of the Limitation Act. Okay, so after the Jignesh Shah's case, this court was concerned on Babulal's case that was being referred. The case where one of the questions that came for consideration was whether the period of limitation for filing application of Section 7 would be different in case of debt secured by mortgage. For which the answering the question, the court considered all the previous decision of the Supreme Court and initiated the principle of law as came out in this. So in that case, Babulal's case, they came out with a guidance basically of 238A. So when Section 238A of the code was read with the above noted consistent decisions, okay, like Innovative Industries, BK Educational Services, Swiss Ribbon, K. Shashidhar, Jignesh Shah, Vasudev Bhojwani, Gaurav Dave, and Sagar Sharma, the following basics came into force. So out of this case, what were the key things that came into picture? And that has been discussed, that was produced here. So what were the key features? That the code is a beneficial legislation intended to put back the corporate data to its fix and not mere a money recovery legislation. So first point that came across was code is a beneficial legislation, not merely a recovery proceedings. CRP is not intended to be adversarial to the corporate data, but aimed at protecting the interest of the corporate data. Okay. What was the third principle that came? The intention of the code is not to give a new lease of life to the debt. Give a new lease of life to the corporate data, but not to the debt which are time bound. So this was a point that needs to be understood. So when a CRP starts, the debt which is time barred, the application is not maintainable. But that continues. That doesn't use away the right to claim the debt. Okay. But that debt will, if it is time barred, will not get a new life by getting into IBC. That is the point that they came out on by all this case laws. Further, the period of limitation for an application seeking the initiation under Section 7 is governed by Article 137 of the Limitation Act. And therefore, 3 years from the date when the right to apply accrues. So, again, the date from right to apply accrues 3 years. That the trigger of the initiation by FC is a default on the part of corporate data. That is to say that the right to apply under code accrues on the date when default occurs. So in the given case, right accrued when the default happened. So what was that date? NPA date. The default referred to in the code is that of a actual non-payment by the corporate data when the debt has become due and payable. That if the default had occurred over 3 years prior to the date of filing of the application would be time barred. Save and except in those cases where on facts the delay of filing may be condoned. This condonation part is something very critical. Okay. So when there is a case where there is a matter which is a time barred matter, but there is sufficient reasoning that is available. When that reasoning is that makes it clear that yes, the time that took place for filing was due to X reason, maybe beyond the power or beyond the capacity to do that filing during that period. So that was done, not filed. Now this right, who has this right to condone the delay? So the judiciary, it has been now in various case laws, it has been very clear through that the judiciary has this power to condone delay, and if that condonation application is admitted, then this time bar thing gets extended. Am I clear on this point? A very important point that needs to be kept in mind is that there can be a matter which is time bar, but there is always an option of condonation to be filed when the matter of time barred case. And if condonation, the reasoning is given properly, and judiciary is of the view that yes, this is fair to give extend the time, then they have a right for that. Okay. After answering the question relating to the debt secured by a mortgage, the Supreme Court took up for the consideration in Babulal case the question regarding applicability of Section 18, though the decision of Jignesh Singh was by 3-member bench, which held in para 21 of its decision that in law, when time begins to run, it can be only extended in the manner provided by Limitation Act. It was held in Babulal by 2-member bench that limitation would begin to run from the date of NPA itself. To come to the said conclusion, the court referred to a decision of Vasudev Bhojwani versus Abhyudaya Bank. But in this case, that is Vasudev Bhojwani's case, where the debt was declared NPA in 1999 and recovery certificate was issued in 2001. But the petition under Section 7 was filed in 2017. It is only because of this that the court in this case, that when recovery certificate was issued, that certificate injured the effectively and completely the appellant's right, as a result of which limitation would have begun ticking. In other words, the court found that the Section 7 application was filed beyond the period of 3 years from the date of recovery certificate and not from the date of declaration of NPA, and therefore what discordant note stuck in Babulal did not and could not have altered the ratio laid down in Jignesh Shah. So what it meant that the cases that case laws that came, each case has a little bit different views. The content were differentiated, and based on that content, the argument took place. So what was good in Babulal's case could not be the same in Jignesh case. So Jignesh Shah case was 3-member bench, and whereas this case, what we are referring of Babulal, is 2-member bench. So 3-member bench decision as such will be revealed, but they say that the ratio dissenting in both the cases are different. So the cloud of doubt created in Babulal with regards to applicability stood clearly cleared subsequently in Arsil versus Vishwal Jaiswal case, wherein court went to the extent of holding that the entry in the balance sheet could also be treated as an acknowledgement in writing, subject, however, to a caveat in the report. So in the coming another matter that we is going to discuss, this will come into play. So that what will come into play, that if there is an audited balance sheet, so in that audited, the notes will be defined, and what the notes means, the thing says, and when that date comes into merely understanding that there is a debt shown in the books of accounts and it is signed, does not give a confirmation. That will be again discussed in the next session. But I'm just drawing, I'm trying to correlate with my fellow thing that this point has not been elaborated here, but it will be elaborated in the case law. So by end of the 2 hours, you will have a very good view on how this limitation act will things have shaped up and the decisions at Supreme Court has taken place. Okay. So in case this court clarified that in the case of Dena Bank versus C. Shiva Kumar Reddy and others, that Babulal was rendered the particular fact of the case, it will be relevant to note that the discussion in para 105 to 107 of the decision in Dena Bank, which read as follows. So that 105 to 107, what it did it say? So they came to a conclusion that in that para, that the aforesaid passage, they came on 105, they say that Babulal was when the date of default has been mentioned in that Babulal case was 2011 being the date of NPA, it remained undisputed that there has neither been any other date of default nor had any suggestion about the acknowledgement of date. So in that case, it was an NPA date that crystallized. In the backdrop of the said fact, under Section 18 of Limitation Act, the principle thereof were applicable and the same would not apply to the application under consideration in view of the averment regarding default therein for want of other averment with regards to the acknowledgement. So it is well settled that the judgment is a precedent for the issue of law that is raised and decided and not any observation made in the facts of the case. As aptly said in the case of Sudesh Pai in the constitutional supremacy revisit. So the correctness of the decision of Dena Bank questioned on the corporate data, wherein it contended that the decision of Dena Bank on the ground, it did not take into account subsection 22 and 22A of section 19 of RDBF Act 93, as well as the clause of 6, 10, 11, and 12 of section 3, and clause 7, 8, and section 5 and 6 and section 14 1B of IBC. While rejecting the said contention, the court reiterated that in no uncertain terms, the Kotak Bank, that a person would be entitled to initiate CRP within 3 years from the date of recovery certificate is issued. So that is the point again goes back to that thing, that what is the date of the right that you get to apply. So it whether it is an NPA date, in this case, whether it was a recovery certificate date, so it goes back to the NPA date. Therefore, the Dena Bank holds the field as on a date that the in the case on the hand, the order of the DRT filed under section 19 dated 2016, it is only thereafter the corporate debtor issued the security confirmation of 2017, apart from making a request for restructuring. Therefore, application filed under section 7 was clearly within 3 years from the date on which right to apply in terms of section 137 accrue. Hence, by enclave, which places is not correct. So here they said, they made it very clear that the right to apply. So confirmation on 2017, which was disputed, that in 2017, this confirmation was received. This date, from that date, 3 years has to be considered. So they confined it and they confirmed that yes, that section 7 is from this last confirmation date, and this confirmation letter is in line issued within the time limits of 3 years, because there has been the application filed under 19 within timelines. So there was an application timelines that was filed. So under Limitation Act, when you go, you get an exclusion provisions are there. So that provision helps him to exclude that period of litigation. So before parting in this case, the court went on to say that the Limitation Act is well developed, well understood. Okay, extinguishes the remedy and not the right. So as I said at the start of this session, that it extinguishes remedy. So what is the remedy? To file the application is the remedy, but it does not extinguish the right. So what is the right? The right is the claim that we have to is received. So 3 years will not come into play in claims. 3 years will come only with respect to filing of application. So this has been very clearly mentioned in this order. So this is why the Act itself contains several provisions for the exclusion of time while computing the period of limitation. Consistently, this court has held that the initiation of CRP under IBC is to put the corporate debtor back on feet, even while repressing the management. In other words, the object has been understood to be something that is beneficial to the corporate debtor, so it survives as a going concern. The scheme of code has been made on that lines. In other words, IBC is projected as a law which enables FC and OCs to initiate CRP, not for helping himself out for the recovery of debt, but they are helping the corporate debtor to survive and continue in the business. The financial and the operational creditors does not go to court or other forums with the mission of helping the corporate debtor to continue as a going concern. But after repeatedly holding that the proceeding under IBC are not in substance the proceeding of recovery of money, this court and statute have effectively applied the law of limitation, and which is intended to apply. So in this case, they went on to clarify that it is maybe pointed out that the schedule of Limitation Act is divided into 3 divisions. First division relates to suit, second division relates to appeals, and third division relates to application. So the first division, which relates to suit, is divided in 10 parts, like suit relating to accounts, suit relating to contracts, suit relating to declaration, suit relating to decrease and instrument, suits relating to immovable properties, suit relating to movable properties, suit relating to tort, suit relating to trust and properties, suit relating to miscellaneous matter, and suits for which no period is prescribed. So the under limitation act, under the first division, following suits are maintainable, and that to them the limitation act applies. The second division of the schedule deals with the appeals, and third division of the schedule of the limitation act is again divided into part. Part 1 deals with the application, part 2 deals with the other application. So application in specific case and other cases. For the law of limitation, the remedy is the goalpost, and the right is the signpost from where the journey commences. A person initiating proceedings in a court must show the existence of right in himself and a remedy for himself. But the IBC is the law where the signpost, namely the right, is for financial and operational creditor, and goalpost, namely the remedy, is for corporate debtor through creditors may also recover a portion of debt. So perhaps the court led to the understanding that undertaking of this journey through a path of limitation and trying to negotiate its way through several bad patches. So they came to a conclusion that in this case, the Section 7 application is maintainable. It is well within the Limitation Act, and it can be allowed. So a key point summary that I can take out of this case law was first the timelines from which date. So it has to be from when that has to be looked. Is that when the right accrues, that has to be looked into. How the Jignesh Shah case shaped up, and how Bhojwani case shaped up, and out of various case laws, what are the various key points, that principles of law that were initiated. So on para 11 of this thing, where they have come down with para 32 of the order. So if you go through that para, you get that principles which are initiated, which gives you a clarity on this. So friends, on this point, this case law, I have tried to make it as simple as clear to you. Hope you have understood it. If you have any questions on this case law where you feel you need a clarification or understanding, I keep it open for that for next 5 minutes before we wind up for the next speaker to take it over. Yes. So in this case, NCLT admitted and reversed the decision of NCLT against Supreme Court admitted. So it went back to what NCLT said. The key point, Section 7 maintainability was there. 2 points on that maintainability. First of all, when the matter is in High Court, there is a parallel proceeding going on. Can it be done under Section 7 of IBC? It said to which all the three said yes, NCLT agreed, NCLAT agreed, Supreme Court agreed. On the Time Limitation Act, the points were discussed where the NCLT said it is admitted, NCLAT objected. They went from the date of that admission was made in 2019, and the last letter of confirmation was on 2017, but that letter was time barred. That was issued after the date was interpreted by NCLAT. Supreme Court, that letter was not time barred. 2017 confirmation was proper confirmation because the date from which that confirmation is to be taken was within that timeline. So there is no issue on that confirmation. And so it is not time barred. And the matter got admitted. Am I clear on this case law, sir? Any point that anyone has? Yes. I think Anil sir is already there. Anil bhai.
If anybody has any questions, they may ask.
Yes, Ms. Snehal ji, how are you?
So, Anil ji, I touched base on certain points that we may take in the session.
Thank you, Snehal sir, for the session. It was very informative and detailed. Thank you. Thank you for your time. And the next session now will be taken by Mr. Anil Goel. Mr. Anil Goel is the founder and chairman of AAA Insolvency Professionals LLP, an insolvency professional entity recognized by IBBI. He has been a co-chairman of ASSOCHAM, National Council for Insolvency and Bankruptcy Code, and member of Advisory Committee of Indian Institute of Insolvency Professionals of ICAI. He specializes in project financing, valuation, financial and legal due diligence. He's a regular speaker in various training programs, seminars, webinars, etc. So you may now start the session.
Thank you very much. Thank you, Anu. And namaste, all the participants. Good afternoon. Finally, the subject which is given to me is the final words on IBC, but that's basically from Supreme Court. And in fact, I was given by the organizers 2 judgments, and maybe that I will immediately start on the PPT. So I will share my PPT. Give me a minute. So friends, we are today discussing on final words on IBC by Supreme Court, and I would be discussing 2 judgments. One is the Asset Reconstruction Company India Limited versus Tulip Star Hotels Limited, and the other is Tech Sharp Engineers Private Limited versus Singvi Movers Limited. So both these judgments are on limitation issue. One was delivered in the month of August and the other was given in the month of September. This Arcil versus Tulip Star Hotel is referring to Section 18 of Limitation Act, whereas the Tech Sharp Engineers Private Limited is on Section 14 of the Limitation Act. Now, Section 18 is kind of renewal, and Section 14 is the whenever some litigation has been started in wrong jurisdiction, that is on that particular side. Incidentally, both these judgments are given by Honorable Justice Indra Banerjee, and Indra Banerjee has also given the judgment of Vidarbha Industries Power Limited. That actually is getting a lot of the judgment is discussed across. So let's start with Asset Construction Company India Limited versus Tulip Star Hotels Limited. The judgment is dated 1st August 2022. So before even I say I will actually take you to another PPT of mine, which was only when I delivered a lecture on limitation law as applicable to insolvency law, and then this relevant slide I have taken out from that PPT. Now the relevant slide, basically these are the important definitions, and after the definition we have the how the limitation period is basic principle in computing the limitation period. And when we see this Section 14 excluded the time where proceedings have been going on a court without jurisdiction. Then going forward, Section 17 and going forward, the section 18. Now, section 18 says that a fresh period of limitation starts if there is a written acknowledgement of any property, right, or liability from a party against whom such property, right, or liability is claimed. It is based on the doctrine of admission. So basically, a fresh period starts on an acknowledgement of any property, right, or liability from a party against whom such property or right or liability is claimed. So this is the admission by the other party. That is very important. So in these two judgments, one we are referring to section 14, and the second we are referring to section 18. In fact, when we go forward in these cases itself, in fact, the section 14, when it says exclusion of time, proceedings bona fide in the court without proceeding, and since we are discussing section 18 first, so I will actually try to see what exactly section 18 says. In section 18, acknowledgement of debt, in fact, earlier also the Supreme Court has given judgments, and those judgments are primarily on various other kind of acknowledgements. In the case of Tilakram versus Nathu, Supreme Court stated that it is not essential that an admission is given in as many words as possible. Rather, if any statement in writing shows that there is the admission of liability shall amount to acknowledgement. So, which may constitute as acknowledgement under section 18 of the Act because of the various judgments. One is the balance sheet. If a balance sheet carries a debt, that also would be signed by the promoters or the company. That also would be considered as an acknowledgement of debt. Emails acknowledging the debt constitute a valid and legal acknowledgement of debt. That is also acknowledgement. Check given by a debtor to pay his dues is an acknowledgement. So acknowledgement has to be prior to the expiration of the limitation period. So these are the basic these are the basics of section 18. And now we can go and discuss the facts of this case, which is Arcel versus Tulip Star Hotels. Now, in this case, the appeal was filed by the financial creditor, which is Arcel, as against the order of NCLAT, and that was like way back in December 2019, holding that the CIRP initiated by the appellant against the corporate debtor V Hotels Limited was barred by the limitation. So that was the NCLAT said it was barred by limitation. And prior to this, in the case of on 3rd of April 2018, the appellant as a financial creditor filed an application under section 7 seeking initiation of CIRP of V Hotels Limited. Then the corporate debtor filed an application before NCLT by praying for dismissal of the application under section 7(2), inter alia contending that the application is barred by limitation. So the adjudicating authority admitted this application. The corporate debtor filed an appeal before NCLT, and they contended that the application is hopelessly barred by the limitation, and the same have been filed after about 8-9 years after the account of the corporate was declared NPA. After the account of the corporate debtor was declared NPA. So the account was declared NPA in 2008. So this was the basic issue in this case. Account was declared NPA in 2008, and there were various proceedings also were being filed in between. In 18, CIRP filed. It was rejected by the adjudicating authority. Appellate authority also rejected it, and finally, the Supreme Court. Now, before the Supreme Court, there were two issues: whether an application under section 7 of the IBC would not be barred by limitation on the ground that it had been filed beyond a period of 3 years from the date of declaration of the loan account of the corporate debtor as NPA, whether there is a bar to the filing of documents in an application under section 7, subsection 2 to 5 of the IBC read with the 2016 rules at any time until a final order either admitting or dismissing the application has been passed. Now, Some documents were not filed before adjudicating authority. Some documents were not even filed before the appellate authority. So this was also a second issue in this case. First issue was the limitation issue. The second issue was whether the documents can be filed or not. Now the appellant means RCIL gave some argument before the Honorable Supreme Court, and the arguments include: first, any part payment made by the respondent would first be appropriated towards the interest amount due. Mere direction to consider the objections of the respondent number 4 would not otherwise means that the jurisdiction was conferred upon the DRT held in Industrial Credit and Development Syndicate, now called ICDS Limited, versus Smithaben H. Patel. The financial statements of the corporate debtor provide a true and fair view of the state of affairs of the company in view of section 128 and 129, read with section 138 of the Companies Act, and also sections 210, 211, 215, 216, 217 of the Companies Act. The application of the appellant under section 7 of the IPC is not barred by the limitation, as there is an acknowledgement under section 18 of the Limitation Act. Now let us see what is the acknowledgement. The acknowledgement was basically, it was the balance sheets, and also you would see that they were actually taking some acknowledgement every time. Now the respondent means the corporate debtor. The corporate debtor responded and submitted their argument that there is no debt due and payable from the corporate debtor to the appellant. The amounts advanced by the consortium to the corporate debtor have been repaid. The application of the appellant under section 7 of the IPC is hopelessly barred by the limitation, and the same having been filed about 8-9 years after the account of the corporate debtor was declared NPA. Even assuming the corporate debtor had acknowledged liability, the last letter of acknowledgement was written in April 2013. The period of limitation still expired in April 2016. The corporate debtor had not acknowledged any debt in its financial statement. The corporate debtor and or its promoter have paid its entire principal due to COC, consisting of appellant and Pegasus. Now, the holding of the NCLAT says the adjudicating authority, having failed to appreciate the aforesaid fact, the impugned order dated 1st May 2019 rejecting the objections of the corporate debtor. The impugned order dated May 2019 passed by the adjudicating authority admitting the application under section 7 are set aside. V Hotels, the corporate debtor, is released from all rigors of law and is allowed to function independently through its board of directors from immediate effect. The RP will submit its fee and cost of the CIRP before the adjudicating authority, who will determine the same, and the amount is as is payable is to be paid by the RCIL, who moved application under section 7, which was not maintainable. The IRP will hand over the management asset to the board of directors. This was the held portion of NCLAT, because the NCLAT in fact said that this adjudicating authority has not rightly admitted the case. When they have not rightly admitted the case, that actually means that the CIRP is closed now. The Supreme Court held in this case that NCLAT erred in law in holding that the books of account of the company could not be treated as acknowledgement of the liability in respect of debt payable to the financial creditor. Supreme Court further held that section 7 subsection 4 of the IBC casts an obligation on the adjudicating authority to ascertain the existence of a default from the records of an information utility or on the basis of other evidences furnished by the financial creditor within 14 days of the receipt of the application. Although this 14 days is nobody complying with. The IBC is not just a statute for recovery of debt, it is also not a statute which only prescribes the modality of the liquidation of a corporate entity unable to pay its debt. It is essentially a statute which works towards the revival of a corporate company unable to pay its debt by appointment of a resolution professional. The provisions of IBC and the rules and regulations framed thereunder be construed liberally in a purposive manner to further the objects of enactment of a statute. Now, in this case, Justice Indra Banerjee is saying that the IBC rules should be construed liberally and for the purpose of revival of the unit. Now, liberally means that again, she's kind of enforcing the judgment that she's delivered in Vidarbha Industries Power, because she said that the amount is available with the company, but it is stuck up in litigation. Once that amount will be released to this company will be revived. So that was the objective of that judgment, that the company can be revived. Okay. So the Supreme Court further says, on a careful reading of the provisions of IBC and in particular the provisions of section 7 subsection 2 to 5 of the IBC read with 2016 adjudicating authority rules, there is no bar to the filing of documents at any time until a final order either admitting or dismissing the application has been filed. So the one legal issue was clarified by the Supreme Court, that there is no bar that the fresh documents can be filed at any stage. Then, as per section 18 of the Limitation Act, an acknowledgement of present subsisting liability made in writing in respect of any right claimed by the opposite party and signed by the party against whom the right is claimed has the effect of commencing a fresh period of limitation from the date on which the acknowledgement is signed. Such acknowledgement need not be accompanied by a promise to pay expressly or even by implication. However, the acknowledgement must be made before the relevant period of limitation has expired. An application under section 7 of IBC would not be barred by limitation on the ground that it had been filed beyond a period of 3 years from the date of declaration of the loan account of the corporate debtor as NPA. If there were an acknowledgement of debt by the corporate debtor before the expiry of the period of limitation of 3 years, that actually should be considered as the limitation period, and the company should be, the CIRP should be commenced in this company. That is the final order. Arcil versus Tulip Star Hotels, the CIRP would start and the documents can be accepted because the limitation period in fact got the extension because of the acknowledgement of debt. That's what we read in section 18 because of the acknowledgement. So this was the acknowledgement of debt. So any questions that you can ask on this judgment so that I can move on to the other judgment. The other judgment is not also pretty, it's again, these are small judgments. I was told that I can actually discuss about these two judgments. Going forward, I can talk about Tech Sharp Engineers Private Limited versus Sanghvi Movers Limited. Again, 19th September 2022, Supreme Court of India, Justice Indra Banerjee. And the law point which was involved in this case, whether the explanation furnished for the delay would constitute sufficient cause or not for condonation of delay would be dependent upon facts of each case or not. So there is a delay and constitute sufficient cause or not for condonation of delay would be dependent on the facts of each case. Yes. Now the facts of this case is that the appeal under section 1662 of the code is filed by the CD, Tech Sharp Engineers Private Limited, impugning the order dated July 2019 passed by NCLAT, where the NCLAT allowed the appeal filed by the respondent operational creditor and set aside the order dated January 29 passed by the NCLT Chennai bench, whereby the NCLT Chennai bench dismissed an application filed by the respondent as barred by limitation. Accordingly, the respondent raised invoices in the year 2012 and 2013. So, first the operational creditor filed an application, and the NCLAT allowed this was set aside. NCLAT allowed the appeal filed by the respondent. Respondent is the operational creditor. So finally, due to non-payment of dues by the appellant, the respondent issued notice on May 2013 for the payment of outstanding hire charges, and the same was replied by the appellant and the correspondence ensued. The appellant issued statutory notice under section 433E 434E, 434 and 439 of the Companies Act in the year 2013. So these three sections are primarily for winding up of the company. That in case a company is not able to pay its debt, then the creditor can go and apply to High Court for winding up of the company. And the same was again replied by the appellant. The correspondent is sued till 2015 until the appellant filed a petition for winding up the appellant before Honorable Madras High Court in the year 2015. So 2015, the 2015, the winding up petition was filed before Madras High Court, which was returned for clearing the defects in the winding up petition. For the correspondence for clearing the defects followed up till 2016. So 1 year, the defects are being removed. On 1st of December 2016, when this IBC came into force, the respondent issued demand notice under Section 9 of the Code for initiating CIRP of the appellant. While order dated 1st of 2019, the Honorable NCLT bench dismissed Section 9 petition, placing reliance on BK Educational Services Private Limited versus Parag Gupta and Associate, and that was on limitation law. Now the respondent appealed to NCLAT under Section 61 of the Code, where the order dated January 19 passed by NCLT was set aside, and the said matter was remitted back to NCLT bench for admitting the CIRP. So first of all, the corporate debtor said that the NCLT in fact rejected the application under Section 9. NCLAT in this matter remitted back to NCLT that the CIRP should be revived, and the observations of the Supreme Court can be seen in this case. For the purpose of limitation, the relevant date is the date on which the right to sue accrues, which is the date when a default occurs. It is well settled by a plethora of judgments of this court, as also different high courts, and in particular the judgment of this court in BK Educational Services Private Limited, that NCLT NCLAT has the discretion to entertain an application appeal after the prescribed limit of limitation. The condition precedent for exercise of such discretion is the existence of sufficient cause for not preferring an appeal and or the application within a period prescribed by limitation. In Ramlal, Motilal and Chotelal versus Reva Coalfields Limited, this court affirmed the view taken by Madras High Court in Krishna versus Chetapan and held that Section 5 of the Limitation Act gives the court a discretion which is to be exercised in the way in which judicial power and discretion ought to be exercised upon principles which are well understood. Now, the Supreme Court further says that the condition precedent for condonation of delay in filing an application or appeal is the existence of sufficient cause, where the explanation furnished for the delay would constitute sufficient cause or not would be dependent on the facts of each case. There cannot be any straitjacket formula for accepting or rejecting the explanation furnished by the appellant for the delay in taking steps. The date of enforcement of the IBC and or the date on which an application could have, on the date of enforcement of the IBC and or the date on which the application could have been first filed under IBC are not relevant in computation of limitation. It would be absurd to hold that CIRP would be initiated by filing an application under Section 9 of the IBC within 3 years from the date on which an application under those provisions of IBC could have first been made before NCLT, even though the right to sue may have occurred decades ago. So the NCLT, the Supreme Court said, like for example, one default occurred in 2010, and in 2016 IBC came, so the limitation period would not restart on the promulgation of IBC. The provisions of Limitation Act are applicable to proceedings under the IBC as far as may be Section 14 subsection 2 of the Limitation Act, which provides for exclusion of time in computing the period of limitation in certain cases, that particular scenario has been dealt with in this. So section 14 subsection 2 have already been seen that in section 14 subsection 2, it says that in case of, in case of wrong jurisdiction. Now this is what is section 14. It says the what is to be excluded, the time spent for prosecuting with due another civil proceedings. Essential requirements for an application, there must be another civil proceedings, or in this case there was a proceedings before Madras High Court for winding up of the company under the Companies Act. So that was the proceedings which was done by the creditor. The suit can be in a court of first instance or appeal or revision. Any kind of suit can be pending, first appeal, first court, appellate court, or revision court. The suit must be in good faith. The court before which it is filed is unable to entertain it due to defect of jurisdiction. So in this particular case, the court entertained because that was the correct jurisdiction. Now, when the litigation was pending, when the application was submitted to a court which was the correct jurisdiction, and that has never been rejected because of the defect of jurisdiction, therefore the proceedings under the Companies Act for winding up the company was in a correct court. It was not even, or it was not in a court having no jurisdiction. High Court of Madras was having proper jurisdiction. In fact, the application was submitted, the defects were removed, and after some time, the IBC was promulgated. Once the IBC was promulgated, the application was filed under the IBC. Although the matter was very old, so therefore, the Supreme Court held that this particular matter is covered under the jurisdiction, and the exemption under section 14 of the Limitation Act is not applicable to this. So these are the two judgments that I referred. In case of any other question that you can ask, or if you want me any question on the latest judgments of the Supreme Court, like Vidarbha or state tax officer versus rainbow papers. So that can also be, if there is any question, that can be discussed. Or even on these judgments, both of the judgments are on limitation, and there are many judgments on limitation law. So these are one on section 18 of the Limitation Act, and the second is on section 14 of the Limitation Act. So the jurisdiction was correct. Therefore, the exemption which was applied by the appellant was not granted by Honorable Supreme Court, and the CIRP could not be started. So this is what is my presentation. Any questions are welcome. Now, I think Mr. Kairav Trivedi is asking that in case of the latest judgment, which is even in the review, the review was dismissed. The review was dismissed because the court, in fact, observed that not every Supreme Court judgment will become law. And it actually will depend upon the facts of the case. In the case of Vidarbha Industries Power Limited, the facts of the case was that that particular company had an arbitration case, and there was a positive award given in favor of the company involving 1,700 crores of rupees, and that arbitration award was even upheld by the High Court concerned High Court. However, the person who was obliged to pay has filed again an application to Supreme Court, and that application was also somehow that was listed before the same bench, and in that application the Honorable Justice Indira Banerjee, she had full information that the company has a very strong case, and in case that application is disposed of, then this company would be revived. So Justice Indira Banerjee thought that this is not really a justice that this company should go to CIRP, because the payment which is due to this company is also due, it is also pending before me, before the same bench. But somehow, which the word that she picked up, that any section 7 application, it may be admitted, but it shall be admitted is not written there. To my understanding, there are some basic compliances which has to be done. Some basic arguments has to be put forward. Number one, that there is a debt, there is a disbursement, there is a default, and there is no dispute. If these are proved, NCLT is bound to pass an order commencing the CIRP, unless the application is filed for fraudulent reason. However, Justice Indira Banerjee found that this company, in case this company goes to insolvency, that will be injustice, because 1,700 crore at any time can be given to this company and the company can be revived. Therefore, that judgment and that judgment probably would not be applicable to all such cases. It has to be a very similar case. Even in this judgment, Justice Indira Banerjee has said that the provisions of IBC should be used liberally. The purpose of the law is not recovery. The purpose of the law is revival of the undertaking or revival of the business. So if the business can be revived without initiating CIRP, that is the first preference. So that's what is the opinion of Justice Indira Banerjee, Supreme Court, and that will become applicable only to a few cases where the other than CIRP, there is another option available, and which is again verifiable and practical for the purpose of a revival. In those cases, maybe that somebody would like to apply Vidarbha Industries Power Limited. This is what is my understanding. And secondly, when we come to the state tax officer versus Rainbow Paper Mills, this was a case where the recovery proceedings under the state tax law that started in 2012. No, it started in 2016, much before the CIRP started. And the year for which this demand was pertaining to, that was 2013. So demand was raised, the demand was crystallized, it went to the recovery process. In the recovery process in 2018, the asset of the company was attached. It was actually attached. It was not based on the lien which is provided in the law, but it was actually attached. However, in that particular judgment, assets were attached during CIRP period. That particular subject was not discussed. And it was not even brought to the knowledge of Supreme Court, because none of the para says that the attachment was done during CIRP and it was prohibited under section 14 because of the moratorium. No attachment could have happened against any civil demand or civil dues or recovery process. But that actually happened. However, this particular subject was not touched by anyone. So now the question is like whether this particular judgment is applicable everywhere. So I have checked up GST law and there is no such provision in GST law. I have also checked up the income tax law. There is no such provision in the income tax law that the assets of the assessee would be having lien in case any demand is outstanding. But now even under the SURFACI Act, when we read section 26 capital E, where it is a requirement that all the financial creditors they will register their transaction of mortgage in the records of CERSEI. That means central registry. It is also very clear that in case the mortgage transaction is registered with CERSEI, then even no other person can come and have any right on that property, that mortgage is final, even if there is any attachment, even if there is any other, whosoever is the first one to register a transaction with the CERSEI, that would be the person who is entitled to that particular property, and the government authorities or state tax officer, or they would not be having any right. So according to my understanding, this state tax officer versus rainbow papers also probably would not be applicable in all cases. It would be applicable only in those cases where the assets are attached by way of an action of recovery. And then also the claim of the tax department would be admitted as a secured operational creditor, and secured operational creditor will fall under section 53(1)(a) and 1(b), and will also share the proceeds pari passu with the other secured creditors. So if you see, in some cases it may have larger voting share, but in some cases it may have very minuscule share. That is also in case the assets are attached before the even start of the CIR. However, in the case of like after this amendment of SARFAESI Act, if any bank, if the transaction of mortgage is already registered with CERSEI, then there should not be any worry, because most of the transactions have now, because since it became mandatory since 2020, January 2020, there was a amendment which made it mandatory for all the secured financial creditor to register their transaction of mortgage with central registry. And that is what is the requirement now also. If that part is done, then the bankers are safe and they would not be adversely impacted by any kind of lien or any kind of attachment. If there is any other question, I can take up. So I believe to the organizers, I think we can conclude the session, or you have any other questions from me?
Yes, sir, we can conclude the session, and we thank you on behalf of all the participants for such a detailed analysis of the Supreme Court cases. Thank you for the session. Thank you to all the participants also for the session. Thank you.
Thank you very much. Thank you to ICSI, and thank you to you and all the participants. All the best for your profession. Thank you. Thanks a lot.
Thank you.